Hello, my name is Rachel Vahey and I am a Senior Technical Consultant here at AJ Bell. I want to talk with you today about advice on defined benefit transfers. On the 5th of June, the FCA issued its latest publications in this area, and that included a host of new rules for advisors operating in this market. So I will go through these new rules today, have a look at the FCA's latest focus, and then finish by looking at what that means for the future of defined benefit transfers, and also for the wider picture of pensions advice. Before we start though, let's remind ourselves of the FCA's interest in this area over the last few years. Although it seemed they got off to a slow start after the introduction of pensions freedoms in 2015, over the past few years, the FCA has certainly been busy. We've seen multiple consultation papers and policy statements and updates about their surveillance and monitoring of advisors working in this area. The most significant developments were probably last year, when we saw in 2018, when we saw which resulted in a new analysis approach, including both the introduction of a TVC and an APTA. Today, though, I want to concentrate on looking at the very latest developments from the FCA. A few weeks ago, very early one Friday morning, we received a batch of documents. So we had the new policy statement, a consultation on guidance, an update on the FCA's work. And in addition to those three, we got the FCA also published an advice checker. Now, this is a communication aimed at consumers to prompt them to consider if they've been given the right advice on a transfer and what to look out for. The FCA also published information aimed at consumers explaining what a defined benefit transfer is and what people should think about when they first look at transferring. I'm going to start off by concentrating on the policy statement. Now, this was in response to a consultation FCA ran last summer, and although we were expecting the results of this consultation earlier this year, they've been slightly delayed due to the COVID-19 outbreak. The main crux of consultation, well, certainly the bit that grabbed the headlines, was whether contingent charging should be banned. So let's start by looking at the FCA's verdict. After much deliberation, the FCA has come down on the side of banning contingent charging for defined benefit transfers and conversions. And this was the announcement that stole many of the headlines a few weeks ago. Contingent charging, as you know, is when the advisor is only paid for the transfer advice if the transfer goes ahead. The FCA felt it created too much of a conflict of interest and was likely to result in bad advice, and so they decided to ban it. The FCA are worried people will try to game the system though, so they have added a few rules to stop this. You can't charge more for ongoing advice than if the fund came from another source. And you can't split your transfer advice charge into transfer advice and implementation costs. The two have to be bunched together. The ban starts from October. There are a few transitionary measures within it, but let's say it starts from October. And from that date, an advisor has to charge the same amount of money for transfer advice, whether or not the transfer goes ahead. This has been a tough decision for the FCA and one they have been grappling with for a few years. The FCA believes contingent charging creates a conflict of interest. If someone is going to be paid money only if a transfer goes ahead, then surely they are going to be more likely to recommend the transfer. That's the FCA's logic. It believes that as most people would not benefit from a transfer, the ban has the potential to reduce the number of customers receiving inappropriate advice. However, the FCA has also been alive to the other side of the argument, that many of the people who are considering a transfer do not have the readily available financial means to pay for the advice. They simply don't have the thousands which it costs sitting idly away in a bank account. But their personal circumstances mean that to transfer may make the best sense for them. And contingent charging allows them to use their defined benefit transfer, often one of their biggest assets, to pay for the advice that they need. If they are unable to take the money from the defined benefit transfer, then they are unable to access the advice. And then the ban creates the risk that those who would be better off by transferring are unable to do so. Now, in all its deliberations, the FCA acknowledges this. It even puts a figure on it. It looks at all the people it thinks will be cut out from getting advice on their transfer, and it reckons out of those people, a third of them would have been financially better off by transferring. But it came down on the side of banning contingent charging. And it still believes that most consumers will not be materially harmed by remaining in their existing defined benefit scheme if they choose not to take advice. But to try and address these claims that those who most need the advice will be prevented from receiving it, the FCA has introduced a set of carve-outs from the contingent charging ban. Now, these are more vulnerable sets of consumers who have certain identifiable circumstances. They are in ill health or dire financial circumstances, dire financial straits, and so they could potentially benefit from a transfer, but they don't have the means to pay for the advice. These consumers will still be able to pay for advice on a contingent basis. However, the FCA is keen to emphasize that just because somebody falls within one of these categories, that doesn't mean that the transfer is automatically suitable. Instead, it fully expects to see cases where the advice is to stay put. Firms still have the responsibility to give suitable advice. The fee advisors charge these carve-out customers cannot be less than the one it would charge other customers. It has to be the same. Although they are able to offer free advice in some exceptional circumstances. The two categories of carve-out are serious ill health and serious financial difficulty, and both only apply if the client doesn't have funds to pay for advice. Let's look at serious ill health first. Now, to meet this criteria, the person has to have a life expectancy of below age 75, or likely to be below age 75. The FCA ummed and ahed about asking people to get evidence from a medical practitioner to prove this. But in the end, they decided it was too impractical, that it was going to cost too much money, or it was going to take too long a time to get. And really, when you think about the timescales for DB transfers, that makes sense. Their other worry was that medical professionals may not be willing to make an assessment on life expectancy and to put that down in writing. Instead, people can self-evidence their ill health. And the FCA reckoned that people have easy access to their own medical files and should be able to do this really quite easily and at a low cost. I think this is a much more practical solution. I think asking for medical professionals to do this would have created impossible situations. But it does seem a little bit peculiar. The FCA are expecting financial advisors to be able to make a call on life expectancy, where the GP won't do so. And who is responsible really for judging that, yes, given a set of medical conditions and family history, that client won't live beyond age 75? financial hardship criteria seems a little bit more robust. There's no prescribed threshold or definitions, and so this gives clients and advisors more flexibility. Guidance will set up circumstances where the test is likely to be met. But the bottom line is that if by paying for the advice, this would mean that the client would be struggling financially and wouldn't be able to pay bills for things like utilities or rent or food, then the FCA considers them as meeting the test. And again, the FCA's guidance is really important in this area. The FCA expects the firm to have a clearly defined policy on how to apply the carve-outs. Such a policy would include setting out that if the firm thinks the person would qualify for a carve-out, then they should offer abridged advice to confirm eligibility. However, that point doesn't answer the question of how somebody would get the funds to pay for abridged advice. The FCA is continuing with its proposal that triage becomes an educational process that gives the customer enough factual information to help them decide whether to proceed with a full advice, whether to proceed to full advice or not. So the advisor cannot give any personalised advice. Now, the FCA recognises that this is going to restrict some advisors' ability to engage with customers, with the aim of filtering out those who aren't suitable candidates for a transfer. But their answer to that was that they hadn't received any clear evidence to persuade them to change their minds. They are going to keep an eye on the triage and how it actually works in practice. And they're going to do this by asking for information about how many customers go through triage. And they're going to ask advisors that as part of new data collection. The FCA has also ruled out allowing advisors to use decision trees or RAG-rated questionnaires as part of the triage process. It believes that as advisors can only make a binary recommendation, you either can transfer or not transfer, then these sort of tools carry too high a risk of crossing the advice boundary. There are lots of examples in the guidance consultation around what a good triage process could look like. And this includes referring clients to an unconnected third-party triage service. Now, these rules have come in immediately, so they've already started. They were effective from the 15th of June 2020. Moving on from triage, I want to now cover abridged advice. This is a new short-form advice process, and the idea is that it should be more affordable than full advice. Again, it's a binary outcome. The advisor can give a personal recommendation that the client should not transfer, or they can say that based on the information they've looked at, the situation is unclear. But if that's the case, then the client has to go on through the full advice process and get a recommendation from there which says, yes, you should transfer, before they can actually transfer. If the client goes through to full advice, the advisor must offset the cost of the abridged advice against the cost of the full advice, so the client doesn't pay twice for the same work. The only exception to that would be if the client went to one advisor for the abridged advice and then to a different advisor for the full advice. The advisor can give abridged advice free of charge if they want to do so, as long as it's not done as part of an attempt to game the ban on contingent charging. The client must have gone through the full advice process if the advisor gets involved to assist with the transfer. Now, just because somebody doesn't receive an outright no, then that's not an indication that the transfer is recommended. The FCA expect that when they look at files on abridged advice, that when people proceed to full advice, then some consumers will be advised not to transfer. If the outcome is not to transfer, then the process would usually stop. The client could still go on to full advice, but the FCA believes this indicates the client will become an insistent client. And when they look at the files in this situation, they would expect in most cases the outcome from full advice would still be don't transfer. Abridged advice starts on the 1st of October 2020. Advisors don't have to offer this, and I think there could be a few who choose not to. But if they do offer it, then it has to be carried out or checked by a pension transfer specialist. In this next slide, I want to look at how the triage process and how the abridged advice fits into the whole defined benefit transfer advice process. So the idea is that a client who is thinking about doing a transfer starts off at the triage point. Now, this is purely educational. The advisor can't give any personalized information whatsoever, but they could show them videos or give them reports explaining what the process is. From that, the client can then go on to take abridged advice, which is the shortened form, cheaper option, or go straight to full advice. If they go to abridged advice, then there are two outcomes. The first outcome could be that the advisor gives a personal recommendation that the person shouldn't transfer and then not to transfer. And in that case, it will usually end with a stop. But they could say that the situation is unclear as to whether they should transfer or not. And if that's the situation, then the client has to go on to the full advice process. And from the full advice process, there are another two outcomes. It could be yes, they have to transfer, or they can go on to a transfer, or it could be no, they should not transfer. And as I said before, that usually ends up with a stop. Now, the reason I say usually is because with all of that, we have insistent customers. So an insistent customer could go through the abridged advice process, be told that no, the advisor does not recommend that they transfer, but to say, well, actually, I think I'm going to look at full advice anyway. And at that point, they go on to the full advice process. If from the full advice, the idea they get a no, do not transfer, we do not recommend you transfer, they might decide to transfer anyway. And again, so the insistent customer could take a different route. The original proposal was abridged advice processors didn't have to collect detailed scheme data. This has now been changed, and the guidance makes it clear firms should consider the benefits of the client's existing scheme. I think this makes a lot more sense. It seemed peculiar to be able to say definitely do not transfer. It's not in your best interest to transfer without understanding where you are transferring from. But it does mean the advisor has to be able to collect and analyse the information on the seeding scheme as part of the cheaper abridged advice process. The FCA has said categorically that an APTA or TVC cannot be included within the abridged advice. Otherwise, advisors would effectively be giving full advice without charging for it, which would undermine the ban on contingent charging. Abridged advice does not consider how funds might be invested if the transfer goes ahead. So the advisor must not assess the risks associated with a specific flexible arrangement. So cutting out these elements, the advisor should be able to offer a low-cost solution. One other thing to note, to allow a transfer to go ahead, the trustees of a defined benefit scheme need to get confirmation that the client has received advice. Whether that advice is yes, you should transfer, or no, you shouldn't, is irrelevant to the trustees. They just need to get confirmation that the client has received that advice. This is under the Pension Schemes Act 2015. The new COBS rules say that this confirmation is only if the client has been through the full advice process. So if they've only been through the abridged advice process, then that's not going to satisfy the defined benefit trustee's requirement. So how many advisors will offer this option? Well, you can see that the FCA has positioned Abridged advice as a low-cost advice to clients who should not transfer. This way, it reckons advisors will be able to attract clients who would otherwise be unwilling to pay for full advice, but be able to say to them, no, I don't think transferring is the right option for you. But at the end of the day, the advisor is giving a personal recommendation not to transfer. And that's only based on half the analysis and half the story. And advisors have to be comfortable with that approach. They have to take full liability for that personal recommendation. Okay, so I want to leave the abridged advice and now go on to look at another aspect of the policy statement. And I think this one is interesting, not only for advisors working in the field of defined benefit transfers, but as a read across to other areas of advice. In the policy statement, the FCA say that ongoing advice charges create a conflict of interest, as an advisor may have a strong monetary incentive to recommend one course of advice over another, and that over time these charges take their toll on the size of the pension fund and therefore on the amount of pension income that the customer can take. I think this is a warning shot across the bows. So under the new rules, the advisor has to show that any proposed scheme is not only as suitable as the customer's workplace pension scheme, but that it is more suitable. So much more stringent requirement than there is currently in place. And I think that the statement in the box in red on the screen is very interesting, and that's why I've picked it out from the policy statement. The FCA's view is that many consumers would not benefit from ongoing advice, as their circumstances are unlikely to change significantly from year to year, and these consumers will be more suited to the default workplace pension scheme fund. I think this is a very powerful statement, and I think it has implications not only for defined benefit transfer advice, but for other areas of pension advice as well. So what's the practical implications of this? Well, again, it all starts 1st of October 2020, and it applies to all advisors, including those that use panels or who are restricted, and including vertically integrated firms. The FCA argues that their rules do not prevent these firms from making an off-panel recommendation. So regardless of whether they're restricted or panels, it doesn't matter. They could still recommend that the transfer goes ahead to the workplace pension scheme. And the FCA says that if these types of advisors, if their business model cannot accommodate this, if they cannot recommend the workplace pension scheme, then they should consider restricting their advice to only customers who don't have an available workplace pension scheme. Now, only the most recently workplace pension scheme has to be considered. Other previous workplace pension schemes can be if the advisor chooses to do so, but it's only the most recently joined one which has to be considered. But the advisor needs to track down all the information for that particular scheme, and that might be easy in some situations, but harder in others. The advisor cannot use standard paragraphs in a suitability report, as these are unlikely to comply. They've got to do more than that than putting down a few paragraphs. It's got to be a fuller consideration. So firms need to change their processes to be able to undertake the required analysis in the APTA of the workplace pension scheme, and therefore recommend a workplace pension scheme where it is suitable. Now, of course, many advisors are going to argue that this isn't significant. In most cases, people transfer at the point of retirement, and the workplace pension scheme, either they haven't got one or it just won't be suitable. And I agree, I think that's probably true. But that doesn't mean that you can ignore this particular area or you can cut corners. If the person has a workplace pension scheme from their current employment, now even if they only intend to remain employed for a few months, they're going to retire very, very soon. The advisor still has to justify why it's not the right choice and why the proposed scheme is more suitable. And they have to include the comparison with the workplace pension scheme in the APTA. Now, none of this is incredibly difficult. Many times it's very obvious why a workplace pension scheme shouldn't be considered. For example, it might not offer flexi access drawdown. But the point is that you cannot ignore this requirement, nor can advisors merely pay lip service to it by adding a couple of paragraphs to the suitability report. If there's a current workplace pension scheme, you have to include a comparison against this in the APTA. I'm going to move now on to suitability reports. There are changes to the suitability reports, and from October onwards, advisors have to include an initial one-page summary to the report. And this has to include a variety of information. Now, the information can be bunched into 4 different areas. The first one is the pension transfer summary. And this looks at the anticipated first-year charges in pounds and pence. Now, that's all charges. That's investment charges, product charges, platform charges, any ad hoc charges, for example, charges to access income, that sort of thing. And it also includes the advisor's ongoing charges, their ongoing management charges. So alongside all of those charges, there's got to be a comparison to the charges that the member would pay if they remained in the DB scheme. Now, often that's going to be nothing. There won't be any direct charges for the member to pay, but that has to be drawn out. The box has to say nil in that situation. You've also got to put in what the monthly, revalued monthly income is going to be from the defined benefit scheme. If the client has a workplace pension scheme, then the charges for that also have to be included within this summary on the front page. And you also have to state how much the transfer advice is going to cost. And even more interesting, you have to say that how many months of defined benefit income it would take to pay for it. So for example, you might say, well, the transfer advice is going to cost you £6,000 and it is going to take you 7 months of your defined benefit income to pay for that cost. And the FCA obviously hope by putting in such a statement that they're going to really direct clients' attention onto the cost of the transfer advice. The next section is to look at the transfer risk warnings. So you have to put down the risks associated with the pension transfer. For example, you giving up a guaranteed income, or that your money might run out before you die, that sort of thing. The client then has to sign to indicate that they understand and accept these risks. And this is all to do with getting evidence of this. You have to put something down about the advisor's recommendation. So you have to summarize what the personal recommendation is, whether to transfer or not to transfer, and also the section of the suitability report that contains the reasons why. You have to say whether it's abridged advice or full advice. And again, the client has to sign to indicate that they intend to follow this transfer advice. And finally, there's a section on ongoing management advice. So there's information about the ongoing services, but also how much it's going to cost the client for these services. And that's in pounds and pence. The client has to sign to indicate that they accept that they are going to pay these charges. But the wording around it is very interesting. The way that the FCA has positioned it is the client is signing something saying, I understand I am going to have to pay however much money for my ongoing management advice costs each month and what the annual cost is as well. And I understand that I'm not required to take this advice. I don't have to pay for it if I don't want to, and that I can cancel this at any time. So again, very powerful wording, which just indicates how strongly the FCA is viewing this particular area of advice and how much they are considering ongoing management advice. This slide shows you what this example will look like in reality. Now, as you can see, it's a little bit fuzzy and it's an awful lot of information just in one slide, which is why we had the 4 boxes there before. But you can see how it will look in practice. And again, under the box of charges, you can see this very powerful statement that says, the pension transfer advice will cost me £6,000. This is equivalent to around 7 months' income from my current scheme. I want to finish this look at the policy statement by looking at just a couple of other requirements. The first one is that before any advice is provided, firms have to give the client in writing the monetary amounts that they're going to pay for abridged and full advice and any subsequent ongoing charges. And this has to be personal to the customer. It's not just the generic advice or charging structure. It's got to put down what it actually is going to cost that particular client. And finally, pension transfer specialists need to undertake a minimum of 15 hours of CPD each year, which focuses specifically on pension transfer advice. 5 hours of that has to come from an external provider. And 9 hours of it has to be structured learning. Now, 15 hours to me sounds like a fairly big ask. And I think a lot of this guide of this CPD is going to be concentrated on the rules and also the guidance that the FCA is going to set in place on what a good process and what a good advice process looks like. I'm going to move on now to look at the FCA's focus. And I think it's worth taking a few minutes to have a look at the latest findings from the FCA on the defined benefit advice, and also to have a look at what it's going to do next. So in this bumper pack of information we received, alongside the policy statement, we also got an update on FCA's recent work. And this latest update is looking at their findings from a sample of 85 firms, which are responsible for the advice on just less than half of all defined benefit transfers. So first of the key findings was looking at material information gaps. And I think this is essentially documentation. Too many firms are still failing to collect the right information, or they're missing it from the client file. One area which the FCA emphasised was evidencing how clients had the correct attitude to the risks of transferring. And they found that this was often missing from the files, this evidence that the client understood the transfer risks. The FCA expects all firms to have appropriate PII cover in place, and if they don't, then it's a case of they simply shouldn't be advising on defined benefit transfers. When you read the update, the FCA say that they realise that the PII market has hardened, that's the terminology they've used, and that costs have increased. But they say that firms can still source PII insurance if they want to, and that's the bottom line. They do say they are going to keep a watching eye on this area, and they're going to collect new information from advisors about this. The FCA also touched on suitability, and again, this was a headline coming out of the reports a few weeks ago. Of the files of the 85 firms it looked at, and these were the most active firms in the market, the good news was that when they were looking at the files from the transfers which took place in 2018, that suitability was up to 60%, which is a good increase. I think it was 47% for the previous year. The bad news is, though, that 17% of those files were still, the transfer was unsuitable and unsuitable advice had been given. I think it's interesting to note how this situation is evolving. Within this work and within this surveillance, the FCA also looked at 10 files which originated for 2019 transfers. And for the ones which are 2019 transfers, then 80% of those were suitable. 20% of them had material information gaps, but none were unsuitable. Now that's only looking at 10 files compared to over 120 going back to 2018. So it's small data, but I'm hoping that's indicative. After looking at these files, the FCA are taking forward 30 enforcement investigations. And with other previous work they've done and other data collection work and monitoring that they've done, they say that over the last year, 700 firms have stopped their permissions for defined benefit transfer advice. So what are the next steps? Well, the FCA is expecting advice firms to improve and to put things right, and they're going to be repeating visits in the hope that that's happened. They're going to conclude these enforcement investigations which are ongoing. They have written to the British Steel Pension Scheme members who have transferred out of the scheme, and they're prompting them to revisit the advice that they received and to complain if necessary. They're putting in place new data collection, and that's going to look at things like PI cover and also how many people fall into these carve-out exemptions for contingent charging. The first period they're collecting data for runs from October to this year to April. So it's just a warning that you're going to have to be reporting new information. So just to get your processes ready for collecting that information from October. Finally, alongside the policy statement, the FCA also published a guidance consultation. This is another 93 pages long, and the consultation sets out proposed changes to non-handbook guidance. So the idea is that it's there to support good practices and developing good processes within firms. The FCA provides examples of what good and poor practice on various areas of defined benefit transfer advice looks like. So when you're putting together your own processes on the basis of these rule changes, and you're looking at what you should be doing and what you shouldn't be doing, then you're going to be looking at this guidance as well alongside to make sure that the good practices that the FCA highlight are reflected in your processes. The FCA is also consulting on a scheme data template designed to help advisors understand what data they need to get from the defined benefit scheme. Okay, so where next? Where are we going to? Well, quite a few rule changes, as I said, within the policy statement, and this is just a summary of those that I've been through. One just to point out at the end, which I haven't covered today, is the new qualification requirements for pension transfer specialists. Because of the COVID-19 outbreak, these have been pushed back a year. So pension transfer specialists aren't expected to have those new qualifications until October next year. I want to finish the presentation by looking at where we go now and what all of these new rules actually mean for advisors who are working in this particular market and for customers who are seeking advice. The first question is, are these new rules going to have any effect on PII cover? And I think the answer is probably going to be no, not really. The FCA has acknowledged that there is a problem with cost in this particular area, but as I said before, they say that's no reason why advisors shouldn't be able to get cover. But I think the costs of PII cover is proving to be a key reason for squeezing availability of advice in this area for clients and customers. Advisors are pulling out of the market because these costs are escalating so much. Is the contingent charge ban going to have much of an effect? Well, the FCA back in 2018 dismissed an outright ban, saying it didn't have the evidence to show that contingent charging is the main driver of poor outcomes. And I'm not entirely convinced that there is a smoking gun this time round, pointing at contingent charging being the main criminal. But it felt this time that the FCA had to take action and that contingent charging was the right target to go for. Is it really going to solve all the defined benefit transfer problems? Probably not. What it might do, though, is to prompt a growth in insistent customers who may feel that they had a right to transfer now. They've been through the advice process and they've had to pay for the advice process. So they are going to do that. They are going to go ahead with the transfer. I think these two factors and other changes within the policy statement are going to lead to a reduction in the access to advice. I don't think as many people are going to be able to afford to take advice, and they're going to be locked out of doing so. You could argue, say, for somebody who is still working, who has and therefore has a workplace pension scheme, who has a small defined benefit scheme from a previous employment, but they're not relying upon it in retirement. They're not in ill health, they've got good life expectancy, but they want to move this little small defined benefit pension. There is a question, are they going to be able to get advice on whether to do that? Is anybody going to be willing to talk to them? And I think all of this is more pertinent in the current environment. There's been some indications that defined benefit transfers have fallen off a little bit in the last couple of months. But now they're going to be back on the increase, and we're going back up to the March levels. I think it's right that we keep our eyes on scams within this area. And certainly the regulators, both regulators and the Money and Pension Service, have taken action to warn people against transferring in a hurry. The pension regulator has gone further. It's done a couple of things. It's allowed trustees to block the transfer processes for a couple of months and just to say, no, we're not going to do any more transfers in this current environment. Although it sounds like anecdotally that most schemes are now back allowing transfers to go ahead. The TPR has also asked trustees to write to anybody who asks for a transfer quotation, to give them just a letter pointing out some issues, and this is headed up from the regulators and from MAPS. But in a way, it's not what's happening now that's going to be indicative of the market. It's more what's going to happen over the next few months and the next few years. Many people are going to be working for an employer who may fail. Now, these people are going to be finding themselves unemployed. They're going to be needing money, they're going to be needing help, they will have a defined benefit pension, and they need advice about what to do. And they need to be able to access that advice. And I think there's a real risk that these people are going to be locked out of accessing advice and getting the help that they need at the time they need it. Finally, I think there are wider implications for pensions advice within this policy statement. First of all, we've had the prioritisation of a workplace pension scheme. And it's not only do you have to prove that the receiving scheme is as suitable as a workplace pension scheme. You have to show that it is more suitable than the workplace pension scheme. And I think the other key area with this is also ongoing management charges. And I think there's a lot within the policy statement to read about that particular area. The idea that somebody who is before retirement, their situation doesn't change year on year, their circumstances don't change year on year, and therefore they have no need of ongoing advice. And the idea that if they're in the workplace pension scheme and if they're in the default workplace pension scheme being looked after by an independent governance committee, then that should be fine for them and they don't need anything else. And the FCA has very much emphasised that point of view, I think, within this policy paper. And I think that's a big read across to all other types of pension advice. I hope that you found this a useful presentation and to help you understand the new rules for this area of advice. The thought I'd really like to leave you with, though, is that there are still very good reasons why a defined benefit transfer is appropriate for some people. And it's important that those people are able to get the advice so that they can make the right decisions for their future. If you do have any questions, then please get in touch. Thank you very much.